Trial resumed. Jury not present.
The court said, "Good morning. Make your appearances, please."
Ms. Murray said, "Good morning, Your Honor." Juliana Murray, Ryan Finkel, and Justin Horton on behalf of the United States. We're joined by paralegal specialist Isabel Loftus.
Mr. Barkan said, "Good morning, Your Honor." Matthew Barkan with defendant Miles Gov't, and joining us shortly will be Ms. Schroff and Mr. Shirik.
The court said, "Please be seated. Is there anything that anyone would like to raise at this time?"
Mr. Finkel said, "Not so much an issue. Just want to note for the court in connection with what was discussed yesterday morning. At about 3 o'clock yesterday, we sent the defense a table of contents that we created for that production, as I understand it, listing each of the documents and what they purported to be. We thought that would be helpful for them."
The court said, "I'd like you to speak into the microphone. You say that you made a table of contents."
Mr. Finkel said, "Yes, our team created a table of contents for that production for Mercantile, which I understand listed each of the documents that were in that production, and what those documents purported to be, based on their title, for example, that sort of thing. We thought that would be helpful. And also what the court requested. I just want to note that we did that. That's all."
Ms. Schroff said, "Nothing from the defense, Your Honor. Good morning."
The court said, "So you'll have the witness back on the stand at 9:29.
Recess. Jury not present.
The court said, "Just now after I left the bench, I received a letter from the defense. I'll hear you on that."
Ms. Schroff said, "Your Honor, just as the letter said, we understand the court is ruled about the longer day. We just ask that the government be held to its order of witnesses, as that would help us given the other constraints that we have detailed in the letter."
The court said, "I'll hear from the government."
Mr. Finkel said, "So, Your Honor, we have always endeavored to provide a good faith estimate in order of our witnesses. Our witnesses are people, many of whom are civilians, some of whom have counsel, some of whom are traveling. There are logistical issues that are sometimes difficult to work out. What I can certainly tell the court is the order that we provide witnesses in is the order we intend to call them in. But sometimes things happen. So to the extent things have changed, we deal with it. That happens at trials. And I think defense counsel knows that. We can certainly provide the defense, as we have been, our order for the upcoming, which we will endeavor to meet. And to the extent something happens, we'll communicate that to the defense in real time. And what I can tell the court is, I've had a number of conversations with members of the defense team, none of whom are here right now, but with other members of the defense team about these scheduling issues. And we've had good conversations about them. So we'll continue to do that. And we'll continue to provide exhibits in advance to help the defense and to make this trial more efficient. We're certainly doing all that we can to be efficient and forthcoming with the defense as possible."
Ms. Schroff said, "Your Honor, that has not been our experience. It is because we've had trouble that one of the members of the defense team spoke to a supervisor at the U.S. Attorney's Office. We continue to have difficulty adjusting to the schedule. Whether it's in good faith or bad faith, the problem is, we're still left in a position where we have to adjust. So, for example, yesterday's witnesses that are going to spill over into today required 2 lawyers to not be in court with the client so they could step out and prepare. That would not be optimal for anyone. This has happened quite a bit throughout the trial. And, of course, it's a given that witnesses are people. That's why they're witnesses. But the problem is, we're also people on the defense side. We also have to adjust. And the biggest juggle we have to make with the situation is schlepping back and forth from MDC, which, by the way, has been in consistent lockdown. The other night, I went at 5 o'clock after the 3 o'clock trial day. It was a holy mess over there. I'm told again that there was a delay. They've changed the count time now. So there are new count times at MDC. So rejiggering of witnesses has like a complete domino effect on the defense team. That is, I haven't finished speaking, Mr. Finkel. I can't see the judge. Thank you. So whether or not the government is endeavoring, that's not what I'm worried about. What I'm worried about is our ability to move around, then pull all of the exhibits. The exhibits are dripping in at the very last second. Yesterday's witnesses. The exhibits were being pulled, I believe, at 1:30 in the morning. So there is no issue of whether or not this is good faith or bad faith. This is where we are. So to the extent the government can give us their witness list earlier than noon on Saturday, that would be great. If they could stick to it, that would be even better. And if we really can't cope, Your Honor, we'll come back to the court.
Mr. Finkel said, "Can I respond to just a few points, Your Honor?"
The court said yes.
Mr. Finkel said, "First, and I hate to say this, but now I have to because of what Ms. Schroff just raised. But there have been a number of occasions where members of the four of us have approached Ms. Schroff in particular to discuss logistical issues, and have been told in no uncertain terms, 'Get away from me.' That's a direct quote. Okay. So the government has tried to address these issues with Ms. Schroff in particular, and that's what we've been told. Thankfully, other members of the defense team have not had that response. And we've had good communication with other members of the defense team. But I want the court to know that just in light of what Ms. Schroff said, also with respect to Ms. Wilson, I think we provided her as a possible witness on May 26th, including her exhibits that we intended to introduce. Because Cross went long for other witnesses, she got pushed to where she is now. The changes in the witness order that happened this week are as follows. On Sunday, and we told the court about this, we determined that we weren't going to call Paolo Sozzi. We wanted to streamline our case, so we took him off the calendar. That's what happened. There was then some flip-flopping between whether it is Kim Espinoza or Jamie Wilson. We thought it would be Kim Espinoza first. Then we thought it would be Jamie Wilson. The reasons why had to do with a family member who was sick of Ms. Wilson's, and then Ms. Espinoza's travel schedule. So those got flip-flopped back and forth. We communicated that as best we could with the defense, and have always endeavored to do so. What's going to happen tonight, Your Honor? And what we do every Friday after the weekends is the four of us, more than the four of us. The case agents and the paralegals, we all go back to 26 Federal. We discuss what happened this week. We discuss who we can call next week, and we try to think about the longer-term plan with respect to the trial. Who our witnesses will be, whether they're available, who we've been in touch with recently, that takes time. We will then go back, look at a calendar, and plot out the witnesses that we think and guess how long the cross will be. That's what we do. We then reach out to counsel or witnesses to make sure that the dates that we think would be best for the jury, frankly, in hearing the evidence, will work for people's schedules. Sometimes we don't learn about scheduling difficulties until after Saturday, right? Because we've been telling the defense by Saturday at noon what our witness order will be. But things happen because there are people involved. So I have no problem, Your Honor. And the government has no problem communicating to the defense. If we can do it tonight, we'll do it tonight. What we anticipate our order of the witnesses will be, and doing everything we can to stick to that order. And we will endeavor to do that. To the extent there are any issues that get raised because of scheduling issues, or what have you, we will tell the defense in real time. There's no problem with that.
The court said, so you expect that you will be able to get them witness list tonight?
Mr. Finkel said, we can do that. The only caveat I'd raise is we might not be able to be in touch with all of the witness and or their counsel. And so that could create some sort of change. So yes, we can get them tonight, the witness list we anticipate. But I just want to be completely forthcoming with the court. Sometimes there are changes as a result of things outside of our control.
The court said, it is typical that the order of witnesses may change during a trial. This is extremely common. However, If it gets to the point where defense counsel cannot represent their client effectively, they may ask for an adjournment, which I would consider granting if I felt that there was a basis for that.
Mr. Finkel said, I understand that, Your Honor. Just to be completely clear, there's no gamesmanship here. This is about scheduling difficulties and trying to fill the days appropriately given what we don't know. And it's sometimes been a black box in terms of how long cross will be. But we hear Your Honor. And we have been very mindful, Your Honor, of what Your Honor told us in the robing room at the beginning of this trial. And we think about that all the time. And I can tell this court that the four of us talk about that a lot. And so what we'll do tonight, we'll try to do it by 9. It might take a little longer as provide a list and order of what we expect the order to be. And what I'll tell Your Honor is to the extent there are changes, we will communicate that to the defense in real time, including the reason why we're changing it, whether it's scheduling or what have you.
The court said, Ms. Schroff, is it true that you said get away from me?
Ms. Schroff said, I did, Your Honor. My past experience with Mr. Finkel on a prior trial before this one has led me to tell him several times that I would not be the point person for him, and that he should speak to some other member of the team. With Mr. Finkel, I have had exactly this issue in a prior trial, and I do not want to get into it before this court. But here's the most important thing. I offered Mr. Finkel 3 other lawyers, and I offer Mr. Finkel email. I stand by that because I have repeatedly told Mr. Finkel that I am uncomfortable proceeding to talk to him off the record. Given my past experience with him on another trial, that was my position, Your Honor. I'm telling the court candidly. So I've had this difficulty before. But there are 3 other members of the team who have borne out these conversations that are long, protracted, and which still have led our team to go to the prosecutor's office's supervisor because we're in the same conundrum as when we started this trial. Mulan is a perfect example, Your Honor. The government said that we should come in earlier and a day longer because they thought that we were playing a game with her schedule. Mulan ended earlier, and then they called 2 other witnesses to back it up. When Mulan was called out of order, it was a strain on us. We still came early, and we still stayed late. So, yes. My historical experience with Mr. Finkel has led me to ask him to talk to other members of the team.
The court said, well, you might make that request, but it is not proper for you simply to say, I will not speak to a member of the prosecution team, or that he cannot speak to you. It's simply improper professionally, and so I'm directing that you may ask that he not address you. But you cannot tell him that you will not engage at all.
Ms. Schroff said, Your Honor, I do not engage with Mr. Finkel off the record because it has been my historical experience that it is not positive for my client. That said, I have offered him every other member of the defense team and email correspondence. That way nobody can say, Ms. Schroff said X and I said Y. It's the best way to proceed because it shows clear communication and transparency. But I will take your court's order as every order this court issues and proceed accordingly. But I do note again, my experience with Mulan, and I note here again that because the entire team had the same difficulty, we escalated the matter to a supervisor. The problem remained as of yesterday. I don't need to belabor this. I'm happy to take the court's instruction and move forward.
Mr. Finkel said, Your Honor, I'm sorry, but I have to respond to some of that. I have to. And now this is before Your Honor, and I'm sorry that it is. It's not just me. It's all 4 of us. Every member of the prosecution team, Ms. Schroff, has expressed this get away from me attitude, which has not been productive. And it's been contrary to what the court ordered us to do in the robing room 2 weeks ago. And, Your Honor, with respect to the Yelly issue that Ms. Schroff raised, the witness prior, and now we have to get into this, the witness prior was Ms. Jenny Lee. There were problems with the translation. There was an issue in which Ms. Schroff was reviewing the transcript to assess whether there were translation issues. I made some suggestions about how to make that more efficient. Ms. Schroff made it clear to me in words, and in her effect essentially, that she was intentionally delaying this because she said the quote was essentially Is the government worried because it has scheduling issues with its witness, in sum and substance? Which was delivered in a sarcastic tone. And that's why we had that reaction about what was going on. And all this, Your Honor, should not before the court. It's contrary to what happened in the robing room. So the bottom line is this, and I want to say this on behalf of this table. And I think on behalf of the table behind us. Is the government is going to do whatever it can to litigate this case in a professional, efficient manner, including by communicating in real time with the defense. Indeed, when we realized the issue with the production, one of the first things we did is call a member of the defense team to tell them about this, and we did that. So we're going to continue to do that. And we're going to continue to work to make sure this trial is efficient for Your Honor, and for the members of the jury.
Ms. Shrofa said, repeatedly the government has said things to this court implying that we're acting in bad faith. An off-the-cuff comment to opposing counsel does not mean there's any gamesmanship on this part. We did not delay a cross.
The court said, well, but saying don't talk to me, that is an improper way of dealing with your adversary. Simply not acceptable.
Ms. Shrofa said, Your Honor, there are 3 other people on this team. The reason I ended communication with Mr. Finkel is it wasn't productive for my team or my client.
The court said, okay, so I want you to understand that you must engage. You cannot simply turn your back.
Ms. Shrofa said, Your Honor, repeatedly we have endeavored to give the government a point person on our team. So one person talks to one person. There is no back and forth between, well, I told Mr. Barkin this, or I told Mr. Shroff this. It is an efficient way to proceed.
The court said, Ms. Shroff, I've heard enough. What I've said is that you can make a request that you not be addressed, but you cannot insist on it. And if it is more efficient for the prosecution team to speak with others, that's fine. But you simply cannot take the position that you're not going to engage the prosecution team. Simply not acceptable.
Ms. Shrofa said, That's fine, Your Honor. I will take the court statement and move forward accordingly. But the record should be clear here. The reason this matter was escalated is because not one of the people on the defense team was able to fulfill their obligation to the client by talking to the government's team on the table ahead of me. It is for that particular reason that we wrote to the supervisor, that we spoke to the supervisor. And we sent a letter to the court. To shift this onto me is fine.
The court said, I've heard enough, Ms. Shroff. I'm going to take a moment and then we'll start. If you'll have the witness, please, brought to the stand.
Recess. Jury not present.
The court said, Please have the jurors brought in.
The law clerk said, Jury entering.
Jury present.
The court said, Please be seated. Good morning, jurors. We're starting 5 minutes late. I'm sorry about that. It's nobody's fault. I do try to stay on time. As for next week, we will start at 9:30. We'll have a break between 11:30 and 12, and then another break between 2:30 and 3 o'clock. We'll stop at 5. Remember, you're still under oath, and you may continue the inquiry.
Ms. Murray said, Thank you, Your Honor.
Jamie Wilson. Resumed. Direct examination continued. By Ms. Murray.
Ms. Loftus, can we please publish Government Exhibit BOP1? Good morning, Ms. Wilson.
Good morning.
When we left off yesterday, we were speaking about the G Club's account at Bank of Princeton. If we could go. Ms. Loftus, to page 26. Ms. Wilson, what is this document?
This is a qualifile or check systems report.
If we can go to the next page, please, Ms. Loftus. Ms. Wilson. What person or entity did Bank of Princeton run a qualifile check for the G Club's account?
For G Club and the signers on the account. This one in particular is for one of the signers, Yvette Wang.
And, Ms. Loftus, if we could zoom in on the table on the top, please. Ms. Wilson. How many different qualifile responses did Bank of Princeton get back for Yenping Wang or Yvette Wang?
9.
What are the various different financial institutions that had qualifile responses for Yvette Wang?
Citibank, Capital One, First Republic Bank, Santander Bank, Next Bank, Signature Bank, and the Bank of Princeton.
Of those 9 inquiries, is it correct that 7 of them were between the period of June 2020 and October 2020?
Yes.
And can you remind us what it means for a quali-file response to come back? What action it reflects?
This means that an account was opened at that financial institution. So they ran the customer through tech systems.
And how, if at all, does the number of quali-file responses for this particular signer Yvette Wang factor into your BSA analysis of the G Club account?
This would make it a little more risky for our institution knowing that somebody opened multiple accounts within a short period of time at multiple different banks.
Why, if at all, would that make it a riskier customer?
Because normally when you have an individual or entity, they maintain banks at a few locations. Maybe 2 or 3 different banks, not 7 or 8 different banks.
Did there come a time when the G Club account was in fact opened at Bank of Princeton?
Yes.
What, if anything, was your involvement with the G Club account after it was opened?
When it was opened, just like any other account, we review all of the opening documents. And we monitor the account. Some accounts are risk high, so we may monitor them a little more frequently than the low-risk account.
And focusing on the G Club account, how, if at all, did you monitor that account in the course of your work as a BSA officer?
We reviewed all the opening documents to include the business documents, the personal documents. We reviewed the money that came into the account when it was opened.
What type of business was G Club?
It was an international luxury living company.
Ms. Loftus, if we could go to page 23 of this exhibit, please. Ms. Wilson, what type of document is this?
This is a certificate of formation.
Is this one of the documents that was submitted in connection with the account opening?
Yes.
If we could zoom in on Article 3 in the middle of the page, please, Ms. Loftus. Ms. Wilson. This section is entitled Article 3, Nature of Business. Can you please read the bolded text of what G Club purports to be in this corporate document?
Membership concierge service with exclusive offers and discounts for luxury hotels and retailers for high net worth individuals from the Asian market. The company may also engage in any other activities authorized by the laws of the government of Puerto Rico.
Thank you. Ms. Wilson, in the course of your BSA analysis, what open source, if any, did you do into G Club?
We did some background research just to Google the business itself to see what type of business it was. What type of luxury services that it offered.
The court said, "Would you remind the jurors what BSA stands for?"
The witness said, yes. BSA is the Bank Secrecy Act. And under the Bank Secrecy Act, we monitor accounts for money laundering and terrorist financing.
What, if anything, were the results of your research, your open source research into G Clubs?
It looked like a startup company. The website really hadn't been developed too much. But we found that it wasn't just G Club. They were linked to other different types of luxury like clothing. And they had their own Bitcoin or cryptocurrency it looked like they were generating. So other different luxury companies within G Club. And that's only found the link to the owner potentially being Miles Gov't.
Who is Miles Gov't?
Miles Gov't, when we did research, had a lot of negative news search on that he had been exiled from China, just different money laundering. Different types of negative news searches that kind of raised a lot of red flags in our opinion.
And what, if anything, did you find from your research about Miles Govt's connection to G Clubs? The company that was seeking to open an account?
He was the owner of that business or the creator for that business.
How, if at all, did Miles Govt's association with G Clubs factor into your BSA analysis?
At that time it was a risk that we didn't want to keep the accounts at our institution. So we chose to close any accounts linked to that entity.
What, if anything, do you recall about the activity in the G Club's account before Bank of Princeton made the decision to close it?
For G Club, they brought in, I want to say it was $10 or $15 million into the bank. And before they could spend the money, we closed the account out to send it out.
Ms. Loftus, can we publish Government Exhibit BOP 3? Ms. Wilson, what type of document is this?
That's a bank statement.
For what entity?
For G Club Operations, LLC.
And looking at the top left there, if we could zoom in on that please, Ms. Loftus. It indicates G Club Operations LLC. What is listed below that?
Memberships 590, Madison Avenue, Floor 21, New York, New York, 10022-2545.
And this is a statement for the period ending November 30th, 2020?
Mr. Barkan said, objection. She's testifying.
What is the statement date please, Ms. Wilson?
The statement ending in November 30th, 2020.
Ms. Loftus, if we could zoom in on the bottom portion which is the account activity here. Ms. Wilson. What was the beginning balance as reflected on this statement for the G Club's memberships account?
-$5.
And on what date?
October 31st, 2020.
How many credits were there during this 1-month period?
7 credits.
For what dollar amount?
$13,500,005.
If can you just look through those? There are 3 on the bottom. If you could read the date and the amount of those credits on this account?
On November 2nd, 2020, there was a miscellaneous credit for $5. On November 3rd, 2020, there's an incoming wire from G Club Operations LLC for $2 million, and on November 3rd, 2020, there's an incoming wire from G Club Operations for $3 million.
Focusing on those bottom 2 incoming wires from G Club Operations, what, if anything, are you able to determine about what accounts for G Clubs those wires came from?
From this statement, you could just tell that the money came from themselves. They're at another institution.
And there are numbers associated with each of those incoming wires after the words, incoming wire. Are those the same numbers for each wire?
No, they're 2 separate wires.
If we can go to the next page, please, Ms. Loftus, the 3rd page. Thank you. And focus in again here on the top portion, the remainder of the incoming wires. For these additional 4, Ms. Wilson. If you could please read us the date of the incoming wire and the amount?
November 4th, 2020 for $2 million, November 4th, 2020 for $2 million, November 6th, 2020 for $2.5 million, November 13th, 2020 for $2 million.
We can take out the zoom. Thank you. Ms. Wilson, what, if anything, were you able to determine about the source of the $13.5 million that came into the G Club's account over the course of a few days in November 2020?
Just that they came from their accounts at other financial institutions.
You mentioned that the Bank of Princeton decided to close G Clubs and additional associated accounts. Is that right?
Correct.
What were the additional accounts that were associated with G Clubs?
The additional accounts were the Greenwich and Lamp Capital.
At the time that G Clubs was opening its account with Bank of Princeton, what association, if any, had it disclosed to the bank about an association with Lamp or Greenwich Land?
The same advisor was the way all 3 accounts were brought to us was from Hatham Khalid and Stephen Lawandy. The same investment advisor for all 3 accounts for our institution.
How, if at all, did the association among these accounts factor into your BSA analysis?
We found some red flags while we were reviewing these accounts and found the links with Miles Gov't. When we looked into Daniel Podhasky, our research had noted that he was also his lawyer. So the fact that all 3 accounts were brought from the same investment advisor along with the links being together from the same investment advisor and the ultimate owner of G Club versus the signer on the other 2 business accounts. We chose to close all 3 accounts.
Just to be clear, Ms. Wilson, you said that Daniel Podhasky was his lawyer. Whose lawyer did you learn Daniel Podhasky was?
Miles Gov't.
When the Bank of Princeton determined that it was going to close the accounts, how, if at all? Did it convey that to the account holders?
The head of our retail reached out to Haytham Khalid to let him know that we were making a risk-based decision to close out their accounts.
How, if at all, did Haytham Khalid respond?
Mr. Barkan said, objection, hearsay.
The court said, sustained.
What response, if any, did the Bank of Princeton receive from the account holders?
Mr. Barkan said, same objection, Your Honor.
The court said, sustained.
When Bank of Princeton decided to close the accounts and informed the account holders of that, were you involved in any further communications regarding the account closures?
I saw the emails and were forwarded the emails that were discussed between the head of our retail and the individual's Haytham Khalid.
And what, if anything, did you learn about the account closure process from those emails?
Mr. Barkan said, same objection, Your Honor.
The court said, sustained.
Ms. Murray said, may I have a moment, Your Honor?
Pause.
Ms. Loftus, can we go to Government Exhibit BOP1 again, please, the bottom of the page? There's a stamp at the bottom, account closed. Ms. Wilson. On what date did the Bank of Princeton close the G Club's account?
November 25, 2020.
If we can go, Ms. Loftus, to the next page, I believe, and on the bottom right here. On what date had Bank of Princeton opened the G Club's account?
10/30/200.
So for approximately how long was that account opened at the Bank of Princeton?
Approximately a month.
And how much money had come into the account during that 1-month period?
Approximately almost $15 million.
Ms. Murray said, nothing further, Your Honor. Thank you.
The court said, cross-examination.
Mr. Barkan said, yes, Your Honor.
Cross-examination. By Mr. Barkan.
Good morning, Ms. Wilson.
Good morning.
You testified on direct about the G Club's account opening, right?
Yes.
Could we pull up GX BOP1, please? We can publish that. Ms. Murray showed this document to you on direct. Right?
Correct.
These are the account opening documents for G Clubs, right?
Correct.
And Ms. Yvette Wang is the owner and signer, is that correct?
Yes, she's a signer on the account.
Can we go to page 2, please? On the top left we see that the second signer is Alex Hadjikaralambas. Right?
Yes.
Can we go to page 13, please? And as asked by the Bank of Princeton. Ms. Wang provided her passport information, isn't that correct?
Correct.
Can we go to page 14, please? And Ms. Wang provided a copy of her credit card from Santander. Isn't that right?
Correct.
Santander is a global bank, right?
Yes.
It's FDIC insured, right?
To my understanding, yes.
If we go to page 15. If we look at the top left, we see it says United States of America Employment Authorization, isn't that right?
Correct.
So Ms. Wang provided proof that she was authorized to work in the United States, right?
Correct.
Go to page 18, please. And Mr. Hadjikaralambas provided his passport information, isn't that right?
Yes.
And can we go to page 19, please? And Mr. Hadjikaralambas provided his driver's license as well. Isn't that right?
Correct.
Can we go to page 21, please? Now at the top this says Bank of Princeton Certification of Beneficial Owner. Right?
Correct.
And if we can zoom in on the middle of the page, please. Letter C says, the following information for each individual, if any, who directly or indirectly through any contract arrangement, understanding, relationship or otherwise owns 25% or more of the equity interest of the legal entity listed above. Did I read that correctly?
Yes.
And below in the grid you see the name Hiharan, right?
Correct.
And there's an address in the United Kingdom, right?
Correct.
And that's his correct address, right?
To the best of our knowledge, yes.
Well, BOP confirmed that that was his correct address, right?
Yes.
Ms. Murray said, objection.
The court said, one moment. It appears that perhaps the jurors are not able to see the screens. Okay, so we need to fix that. Is it possible for you to go to an area that doesn't require the screen? Or do you need the screen for every question?
Mr. Barkan said, I do need the screen at this time, Your Honor.
The court said, are you able to lean over and look at the screen? We're working on getting your screens back up. But in the meantime, if you'll just look over at the screen that is in the second row. Okay, so you may continue.
Mr. Barkan said, thank you, Your Honor. Could we go up to page 20, please? Could we zoom in on the top left there? Mr. He provided his passport information, isn't that right?
Correct.
And so he disclosed himself as an owner of 25% or more of the equity of G Clubs, isn't that right?
Yes.
Ms. Wilson, you testified on direct about Qualifile, right?
Correct.
It's part of the verification process for new customers, isn't that right?
Yes.
Is it fair to say that that's part of Bank of Princeton's KYC process or Know Your Customer process?
Yes.
Can we go to page 26, please, and can we zoom in a bit? That says Qualifile response, correct?
Yes.
And if we could zoom out. If we look a little further down the page it says, business information, right?
Yes.
And it says G Club Operations, LLC, right?
Yes.
And towards the bottom do you see where it says, check systems history?
Yes.
And below that it says, no closures found, right?
Correct.
It says no purchase debt found, right?
Correct.
It says no previous inquiries found, isn't that right?
Yes.
So Qualifile found nothing problematic with the G Club Operations, LLC report, isn't that correct?
Yes.
Can we go to page 27, please? This is the Qualifile report for Ms. Wang, isn't that right?
Yes.
So if we zoom in on the bottom of the page, we see where it says check systems history, right?
Yes.
And again no closures found, right?
No.
No purchase debt found, right?
Correct.
Can we go to page E28, please? So you testified on direct that part of the Qualifile inquiry is an inquiry into other banks where the applicant had opened other accounts. Isn't that right?
Yes.
And so when other banks asked Ms. Wang, she provided her documentation to those banks, right?
Yes.
So she provided it to Santander Bank?
Yes.
Ms. Murray said, objection. How would this witness know if Ms. Wang provided her information to a different bank?
The court said, so you can testify about what you know. If you happen to know whether she provided that information to Santander, you may answer. If you don't know, then you'll say you don't know.
I don't know for a fact what she supplied them. But I know by this page that she went to the bank and inquired to open an account there.
Fair enough. And same with Citibank, right?
Correct.
And same with Capital One, right?
Correct.
If we could go back to page 27 and zoom in on the middle of the page. So for Ms. Wang, do you see where it says account actions?
Yes.
And it says action accept, right?
Right.
And it says recommended actions, open account, right?
Yes.
Could we go to page 30, please? This is the Qualifile report for Alex Hadjikaralambas, right?
Right.
And the recommended action here is open account, right?
Right.
And it says action, accept, right?
Yes.
Ms. Wilson, what is an ORM inquiry?
I'm not sure.
Could we go to page 31, zoom in on the top?
That's an OFAC inquiry.
I couldn't hear you.
The OFAC inquiry, the Office of Foreign Asset Control.
And is the inquiry run as part of the bank's KYC process for new customers?
Yes.
And so at the top here it says ORM inquiry Yangping Wang, right?
Yes.
And then in a box it says suspect matches, right?
Correct.
What is a suspect match?
A suspect match that's what they're running it against, so Yanping Wang's name is there. And it's showing that no matches were found. If there were potential matches, they would be listed below instead of no matches found.
So the bank's OFAC inquiry found no suspect matches for Yanping Wang, right?
Correct.
Can we go to the top of the page E32, please? And can we zoom in on the top? So this page shows the OFAC inquiry result for Alex Hadjikaralambas.
Correct.
And for Mr. Hadjikaralambas there's no suspect matches, right?
Correct.
And can we go to the page 33, please, and can we zoom in on the top? And this shows the ORM inquiry for G Club Operation, LLC, right?
Correct.
And again no suspect matches found, right?
Correct.
Thank you. We can take that down. Ms. Wilson, other than the qualifile and the OFAC, were there any other account opening KYC processes that Bank of Princeton ran on these accounts?
We ran qualifile, OFAC. And other than that we just review the documents that are provided by the signers opening the account for the businesses and themselves.
So as we've reviewed, the signers for the G Club operations accounts provided all the ID that the Bank of Princeton asked for. Isn't that right?
Correct.
And so Ms. Wang and Mr. Hadjikaralambas provided their ID, right?
Correct.
And they passed the bank's KYC process, right?
Correct.
And G Club operation itself passed the bank's KYC process, right?
Yes.
And the beneficial owner was disclosed, right?
One of them, yes.
The beneficial owner, Mr. Haran, he was disclosed, right?
Correct.
And the bank KYC system recommended that the account be opened, isn't that right?
Yes.
And the bank in fact opened the accounts, right?
Correct.
And permitted them to be funded, right?
Correct.
You also testified on direct that an entity called Greenwich Land, LLC had accounts at the bank, right?
Yes.
And that it was Mr. Podhasky who signed the documents to open that account, right?
Yes.
And you would agree that Mr. Podhasky provided the identification required by the Bank of Princeton to open that account, right?
Yes.
And Mr. Podhasky gave his true profession when he disclosed that he was a lawyer, right?
Yes.
And it's simple to verify if a person is a lawyer in good standing, right?
Ms. Murray said, objection.
The court said, you may answer if you know.
We can do research through the internet to find if they are currently a lawyer based on website. So whether we want to trust the internet research that is provided, then there's a potential we could verify that.
And you did that research with Mr. Podhasky, right?
I did research on Podhasky.
Ms. Murray said, objection, per the court's prior ruling on this matter.
The court said, if you'll step up, please.
Continued on next page. At the sidebar,
The court said, so on direct Mr. Podhasky was identified as the attorney for G Clubs, so it's not improper to inquire as to whether he was in good standing. Do you plan to ask any more questions?
Mr. Barkan said, a couple, Your Honor. Just to identify the fact that it was disclosed that he was a lawyer at the time the opening of the account. It's not something they found out later.
Ms. Murray said, Your Honor, we understand, and we believe that has been established. To the extent there are additional questions into his good standing and any results that the bank found about his good standing, which are suggestive and imply that there was in some way giving some legitimacy to what was happening, that's firmly within the court's prior ruling.
Mr. Barkan said, Your Honor, I have no intention of asking questions about whether he was in good standing.
The court said, you did ask a question as to whether she did research. 1 minute. You did ask questions as to whether she researched his status as a lawyer in good standing, which I find to be acceptable to go that far because his status as a lawyer was raised in the direct. But calling further attention to his status as a lawyer is not proper.
Mr. Barkan said, Your Honor, One of the pieces of identification that he submitted was his attorney ID card to the bank. And I was going to confirm that they had that information at the time before the account was opened. It was submitted with the application. So if they are going to complain that they later discovered that he was an attorney, I think it's important for the jury to hear.
The court said, if it was part of the application process which Ms. Murray went through, then I think it's fine for you to ask that one question.
Ms. Murray said, Your Honor, with respect to that point, again we think that has been established. There's been no allegation by the witness that Mr. Podhasky didn't disclose the fact that he was an attorney in the course of the account opening. In fact, she said that was one of the red flags for her in reviewing the accounts. But to continue to inquire into this matter beyond just establishing it, we believe again falls firmly within the court's ruling and is attempting to paint this with the approval of some kind of legal counsel.
The court said, so you're going to ask the question about the ID, which I find acceptable. Did you want to ask any further questions?
Mr. Barkan said, No, Your Honor.
The court said, all righty. Thank you.
Continued on next page. In open court, jury present. By Mr. Barkan.
Can we please pull up GX BOP 7? Ms. Wilson. This is an identification that Mr. Podhasky provided with the bank application, right?
Correct.
And in the lower left-hand corner it says, Attorney Secure Pass, correct?
Ms. Murray said, Objection, Your Honor.
The court said, overruled.
Correct.
My only further question here is, this was submitted with the account opening documents, correct?
Ms. Murray said, Asked and answered.
The court said, sustained.
So Bank of Princeton knew that Mr. Podhasky was an attorney.
Ms. Murray said, Asked and answered.
The court said, sustained.
Mr. Barkan said, I'll move on. In addition to Mr. Podhasky's ID, the beneficial owner of Greenwich Land Hinkai Ngok was disclosed. Isn't that right?
Yes.
And her identification was also provided, right?
Yes.
And Mr. Podhasky and Greenwich Land and Ms. Ngok passed the bank's KYC process, isn't that right?
Yes.
And only then did the Bank of Princeton open the accounts for Greenwich Land, right?
Yes.
And permitted them to be funded, right?
Yes.
You also testified on direct that an entity called Lamp Capital, LLC had accounts at the bank, right?
Yes.
Mr. Podhasky signed those account opening documents as well, right?
Yes.
And he provided the identification that was required by Bank of Princeton, right?
Yes.
And the beneficial owner of Lamp Capital was also disclosed, right?
Yes.
And his document, his passport, was also provided, isn't that right?
Yes.
And so each of Mr. Podhasky, Lamp Capital, and the beneficial owner passed the bank's KYC process, right?
Yes.
And as a result of that, the bank opened accounts for Lamp Capital, isn't that right?
Yes.
And permitted them to be funded, right?
Ms. Murray said, Asked and answered.
The court said, sustained.
You testified on direct that you found it concerning that Mr. Podhasky was a signer on the Greenwich and Lamp accounts even though he wasn't the beneficial owner. Isn't that right?
That he wasn't the owners of the businesses, yes.
The court said, if you would bring the mic closer to you, and the same for you, Mr. Barkan.
I didn't hear the answer to the question.
That he was not the owner of either of the businesses.
Right. But the application for Greenwich Land disclosed that Ms. Ngok was the beneficial owner, right?
Right.
And for Lamp Capital, that application disclosed that Cheong Guo was the beneficial owner, right?
Yeah, I don't remember the exact names. But we were disclosed the two different individuals for beneficial owners for the businesses.
And so the fact that Mr. Podhasky wasn't the beneficial owner was not a problem for Bank of Princeton at the time the accounts were opened. Right?
Right.
You testified that it was concerning to you the amount of money that was flowing through these accounts. Isn't that right?
Correct.
G Club, we saw on direct about 13.5 million in its account at one time.
Yes.
Greenwich Land had about 10 million.
Yes.
Lamp Capital had about 11 million.
Yes.
And you testified that nobody had brought that kind of money into Bank of Princeton, correct?
Ms. Murray said, objection, mischaracterizes her testimony.
The court said, sustained.
Had you seen that kind of money flow through Bank of Princeton before?
Not without a loan relationship, to my recollection.
I'm sorry.
Not without a loan relationship, to my recollection.
In fact, Bank of Princeton knew before the G Club accounts were open how much money was going to be brought into that account. Right?
Ms. Murray said, objection.
No. No.
The court said, overruled. You may answer.
Could we call up GXSW 2032, which is in evidence? Thank you. Can we go to page 5 of the PDF, please? And can we focus on that bottom email, please? Ms. Wilson, do you see that this is an October 21st email from Haytham Khalid to Deborah Von Gonten and Miriam Colon at the Bank of Princeton?
Yes.
Do you know Ms. Von Gonten and Ms. Colon?
I do.
So they're your colleagues at the bank, right?
Yes.
Can you read the second paragraph down below? Hi Deborah and Miriam. It begins with, we have another client.
We have another client that has a banking relationship with Signature. They are a startup with international membership service for luxury living with approximately 1,600 members. Current balances are 15 million, and we want to help them set up a bank account with Princeton as well. Can you please email me money market account rates available? That's what MMA stands for.
You can take that down. Thank you. Ms. Wilson. Do you now understand that the Bank of Princeton was told ahead of time how much money G clubs would be bringing into the account?
Ms. Murray said, objection, Your Honor.
The court said, overruled. You may answer.
I was not on that email chain, so I was not aware when the accounts were being opened. But those individuals would have been aware.
You were asked on direct about a loan agreement between ACA Capital Group Limited and Greenwich Land. Do you remember that?
Yes.
Can we call up GX, 40, which is in evidence? And that loan agreement was provided by Mr. Podhasky, right?
Correct.
Can we scroll down to the bottom of page 2, top of page 3? So this is an email from Miriam Colon to Haytham Khalid and Daniel Podhasky, correct?
Yes.
And you were shown this on direct yesterday, right?
Yes.
And so your colleague Ms. Colon had emailed Mr. Khalid and Mr. Podhasky on, this is November 24th, right?
Yes.
And she asked for information that she had requested earlier, right?
Yes.
Can we scroll further up to page 2, please? So this is November 24th email later that day. Mr. Podhasky replies and he says, thank you for following up. We will get back to you shortly. I read that correctly. Right?
Yes.
And again it's Tuesday, November 24th, right?
Yes.
Can we scroll up to the top half? On December 1st, Ms. Colon reiterates her request for information from Mr. Podhasky and Mr. Khalid, right?
Yes.
And if we scroll up to the bottom of page 1, please. So we see Mr. Podhasky replies the next day on December 2nd, right?
Yes.
And he supplies the requested information in the loan agreement, right?
Yes.
Ms. Wilson, you're aware that Thanksgiving falls on the 4th Thursday of every November, right?
Yes.
And in 2020, the 4th Thursday of November was November 26th, right?
I don't exactly know.
I will represent to you.
I don't have a calendar.
The court said, don't testify.
Friday was November 27th, isn't that right?
If Thursday was the 26th, then, yeah.
And the 28th and 29th would have been the weekend, right?
Yes.
And Monday would have been the 30th, right?
Correct.
And so 2 days later on December 2nd. Mr. Podhasky replies with the requested information of the loan agreement, isn't that right?
Yes, he replied on December 2nd.
Could we go to page 5 of the PDF, please? And can we zoom in on the top half? This is the loan agreement that Mr. Podhasky provided, right?
Yes.
You were shown this yesterday on Direct, right?
Yes.
Mr. Podhasky is a signatory on the Greenwich Land accounts at BOP, right?
Yes.
And if you look at number 1, ACA Capital is based in Hong Kong, right?
Yes.
You can take that down. Ms. Wilson. You testified that there came a time when you made a recommendation to close the accounts, right?
Yes.
You had begun conducting some website research into G clubs.
Yes.
I think you testified you did some Googling.
Yes.
And you did it personally, right?
I did.
And you discovered what you called negative news, right?
Correct.
And as the BSA officer, you consider negative news when you evaluate risk to the bank, right?
Yes.
So you found the names of other about businesses linked to Mr. Gov't, isn't that right?
Yes.
You saw the name GTV, right?
Yes.
But the negative news was from abroad, right?
It was on the internet, so.
Do you recall telling the government that the news you found about Mr. Gov't came from abroad, right?
Some of it, yes.
You actually told the government that there was not a lot of negative news about Mr. Gov't from in the United States. Isn't that right?
I didn't say those exact words, but I found a lot of negative news on him.
From abroad, right?
That he was exiled from China, yes.
So you learned that Mr. Gov't was in trouble with the Chinese authorities, right?
Yes.
And you learned he had been exiled from China, right?
Correct.
And you learned that the Chinese government had issued an Interpol red notice for him, right?
I don't know what that is.
You learned that the Chinese government had frozen his assets, right?
No, I did not.
Even just with the negative news stories you found about what the Chinese government had done. That was enough for you to close the accounts for LAMP, Greenwich and G clubs, right?
Ms. Murray said, objection, mischaracterizes.
The court said, sustained.
Mr. Barkan said, I have nothing further, Your Honor. Thank you, Ms. Wilson.
Redirect examination. By Ms. Murray.
Ms. Wilson, you were asked a few questions on cross-examine about the G Club qualifile response. Do you recall those?
Yes.
Ms. Loftus, if we could please pull that up. It's Government Exhibit BOP 1, and we'll go to page 26. While we're pulling that up, Ms. Wilson, how, if at all, did the qualifile results factor into your mosaic of considerations in conducting a BSA analysis?
If a qualifile report says to decline an account, then we do automatically decline the account at the bank. But the other factors that we look into is to make sure that sometimes people put freezes on their social security number. So we want to make sure there's no freezes. And we do look at how many accounts are opened within the time period on that qualifile that may be listed. And if multiple accounts are opened at multiple institutions within a short period of time, that can raise a lot of red flags to us because that's what fraudsters will do. They open multiple accounts at different banks. It's just a red flag to me as a BSA officer. Usually as a human being or a business, you only have accounts at very few banks.
And looking at this, Ms. Wilson, on what date was the G Club qualifile report run?
November 3, 2020.
And, Ms. Loftus, if we can please go to page 25 of this exhibit, the page before. On what date was G Club operations established as a business?
October 7, 2020.
Approximately how many weeks before the qualifile report was run was G Clubs brought into existence as a company?
Less than a month.
We can take that down, Ms. Loftus. You were also asked some questions about Howard&He's address on cross-examination. Do you recall those questions?
Yes.
Have you ever been to Howard house in the United States?
No.
Do you know whether the address provided to the Bank of Princeton is where he in fact lives?
No.
You were also asked questions about ACA Capital's address listed in Hong Kong, correct?
Correct.
Have you ever been to ACA Capital's offices at that address in Hong Kong?
No.
Do you know whether ACA Capital actually operates out of the address it provided to the bank?
No.
Have you ever met Chung Guo, who was listed as the ultimate beneficial owner of the accounts?
No.
Have you ever met Yvette Wang, who was listed as the signer on various of the accounts?
No.
With respect to your BSA analysis of these three customers, Lamp Capital, Greenwich Land, and G Clubs, what, if anything, was relevant to your BSA analysis about the status of the ultimate beneficial owners?
They were non-resident aliens, which means they're not U.S. citizens. So our bank protocol is any non-resident alien, whether they're just a beneficial owner on the signer on the account. We monitor them a little more frequently because those types of individuals usually are sending a higher volume of wires potentially in and out of the country. So we like to monitor that.
And what, if anything, did you find about the activity in these accounts during the time period you were monitoring it that was relevant to your BSA analysis of the risk of these accounts?
A high volume of funds came into the account and was quickly being sent out. And the activity was not in line with the types of businesses that we would normally associate with the investment capitals or real estate businesses.
And what types of businesses were Lamp Capital and Greenwich Land described as to the bank?
Mr. Barkan said, objection, scope.
The court said, overruled. You may answer.
They were investment advisor or real estate.
Ms. Murray said, may I have a moment, Your Honor?
The court said yes.
Ms. Murray said, nothing further.
The court said recross.
Recross examination. By Mr. Barkan.
Ms. Wilson. The beneficial owners provided each and every identification document that the Bank of Princeton required to open these accounts. Right?
Correct.
Each of Greenwich, Lamp, and G Club passed the bank's KYC process, right?
At account opening, yes.
And the accounts were opened and funded, right?
Correct.
Mr.
Barkan said, thank you. Nothing further.
The court said, anything further?
Ms. Murray said, no, Your Honor. Thank you.
The court said you may step out.
The witness is excused.